So this is our monthly study group. Today, we are going to be talking about debt collection under state law. However, Mike Checky and I were just discussing a case that I'd just like to run by you, which is causing a stir in California. And what the holding is this, is that if you have a multi-unit house, such as a duplex, quadplex, etc., you can only claim a homestead in the square footage you occupy. So if you have tenants in the other units and you have no right of entry without notice, then the trustee and debtors council are going to have to get their calculator out to determine what the homestead is going to be. Any comments on that? Thoughts?
Yeah, I'd like to say that I think it doesn't apply to duplexes. Is that correct?
It was a duplex.
It was. Wow.
So it's on appeal to the BAP. We'll see what the BAP does. Funny enough, it's not the trustee. The trustee is not a litigant. It's a secured creditor, which is quite odd. But anyway, any other thoughts? All right, let's see how many we've got here. Let's look at the participants. Okay, we've got a good group. Welcome, Z.
Hi, Wes.
How are you?
I'm good. I'm not gonna take the specialization test. I am not qualified, but I like to hear your voice and learn from you. So please do not pick on me. I did not do the homework, please.
Okay, all right, I will not. I would point out that Z is a certified specialist in appellate law, though, correct?
Yes, I am. So interesting hearing about the BAP.
So there you go. Okay, well, let's begin. With regards to pre-petition lawsuits and debt collection under state law and unsecured claims, for debtors counsel, there are all kinds of information that you can garner by a review of the debtor's pre-petition litigation. Lucy just sent everybody a message on chat, and it says, if you attended today's program on MCLE credit, please email with your bar number. So I hope everybody saw Lucy's chat. So, for example, with regard to, let's go through the schedule, Schedule A. If there's a partition action pending, then that'd be something to list in Schedule A. With regards to Schedule B, any kind of disputed assets that the debtor may have legal title to, but not equitable title, and vice versa, would go in Schedule B. Obviously, for Schedule F and notice purposes, you want to make sure you capture all the plaintiffs, creditor plaintiffs. Going back to Schedule B, to the extent the debtor's a plaintiff, you have to list that in Schedule B, or those, and hopefully you write down the case number, the state court case number, and give some idea of the value of the claim. Moving on to Schedule D, if there were garnishments or levies that are going to have to be released by the sheriff, that should be listed. Leslie, what is your, I think Leslie's on the phone. Leslie, what is your policy with regards to pre-341A sheriff levies that you get notice of?
Sorry, you're kind of cutting in and out for me. What was the question?
It's okay. What is your position on pre-341A sheriff levies that you're served notice with? In other words, you get a letter from the sheriff saying, I'm holding this bank account. What is your policies on that?
Well, usually it's too little money to care about. But if it is money that's already been collected by the sheriff, as opposed to just a notice of the levy exists, then I would look to Schedule C to see if it's potentially exempted. Otherwise, or I would ask for it to be turned over if it's not exempt or exemptable.
What is the most money you've had turned over from the sheriff in your career?
I think I've only had one where it was enough money to bother with, and that it was not exempt under the wild card, and it was maybe, I don't know, like $8,000 to $10,000 in my recollection.
I had a case for $77,000, so that wasn't bad. Are there any other trustees on the call? My policy is if it's scheduled, I release it. If it's not, I don't, and I wait for the 3:40 limit. So, all right, let's see, moving on, let's see what else. So then we go into Schedule H, and there you would have co-debtors. So co-defendants would give rise. Oh, we have a comment? Jonathan. Do you have a comment?
No, I don't. Sorry, I dialed in a little late, Trustee Avery. My apologies. I had a call go longer than expected. I didn't mean to disrupt you.
That's all right. So Schedule H, co-debtors, you could get co-defendants from pre-petition litigation. What else? And then I guess going to the statement of affairs, you have to list all the lawsuits, pending lawsuits in the statement of affairs. Anything I've missed? All right. All right, well, let's crack open the book. And let's begin. Okay, on page 36, they have the history of the lawsuit. And you've got your pre-litigation, so I'm looking at page 36. So you're looking at your pre-litigation period. So you have debt incurred, debt due, default, non-judicial collection efforts, and then summons issued and served. Okay, so what we're talking about here is at this point, you consider your prejudgment remedies, which we're going to be talking about, and they include replevin, receivership, injunction, attachment, and garnishment, and also lis pendens. With regards to lis pendens, do we have anybody out of state who has familiar with lis pendens?
Sure, I think we have familiarity with lis pendens. We file them fairly regularly.
Okay, tell me about the dangers to a trustee of recording a lis pendens.
Well, you need to have a lawsuit filed first and have a reasonable basis for filing the lis pendens. But once a lawsuit is initiated, if it's with respect to real property, and then you can record a lis pendens. And I first go to Chris, who's also on the call, to make sure that we're good to get that going. That's what I do to protect myself.
Well, we make sure that that the lawsuit has to do with possession or title to the real property. You have to follow the California laws, statutes about providing notice to the homeowner, to the debtor, and recording that notice in the bankruptcy court. Things you have to follow the statute very particularly, because a lis pendens does create a cloud on title for the real property.
A couple things. Number one, I regularly record lis pendens without a lawsuit. In other words, I just because you don't have time, and I've never had that challenge.
Ah.
So I just use the case, sign it. Under California.
Oh, I'm sorry. I think we do two different things. We do a lis pendens when there's an adversary proceeding. We also often record the petition or an interest of the bankruptcy estate on the real property. It's a notice of the bankruptcy estate has an interest in the property. We do that without having to fly with the California statutes. I believe that's what you're talking about.
Well, I think that would be enough. I mean, at the end of the day, it's not the court, it's the title officer. Does the title officer buy this? I wanted to say that there's a trap here, because under California law, there's a presumption that if you've recorded lis pendens, you're ready to go to trial, and that you've got everything ready to go. And if not, there's a problem. And I have been in a situation where someone's moving for summary judgment against me on that basis. So this a lis pendens plus the clouding and title damages. A lis pendens is something that you never do blindly. And you give some thought to your opponent, you give some thought to the strength of your case, you give some, who's the judge, do you trust the judge, etc. But obviously a lis pendens is a trustee's best friend.
I've gotten my lis pendens audited by the U.S. trustee before. They came at the fee app stage. They said, Mr. Mang, you did it wrong. You did it in the wrong order. We think that this lis pendens is legally ineffective. We request that your firm voluntarily reduce your fee application by $2,000 all the time you spent doing the lis pendens. And we're like, okay, fine.
I'm sorry.
That's a danger.
No, but I mean that just makes, as an attorney, it just makes you feel sick, doesn't it? And you say, okay. The thing is, you have to protect the client. And if they made you cut your fees, they made you cut your fees. But if the property was encumbered over the lis pendens or without a lis pendens or transferred again, that's far worse. So, all right. Just out of curiosity, Tinho, do you record or create lis pendens and record them just based on the bankruptcy case?
We've done it before. Every time we do it, we have a debate about how hard someone's going to come down on us, and people usually don't. I mean, if they make a fuss, then we just get rid of it by stipulation, I think.
Right.
Well, I'm telling you that just filing something or the document that we file in the alternative is just called a notice of bankruptcy, I believe. And it's recorded with the county as well. And it doesn't have the repercussions that a lis pendens would have, but it gives the notice to the title company. So you might, I mean, there is a more, less risky alternative.
If you have a chance, and if you have it at your fingertips, could you send in chat a case number on one of the cases where you've done that so we could see what it looks like? If you could, if you can think of it.
Sure, Chris is going to get right on that.
Yeah, I'll find it.
Okay. Thank you. Thank you. All right, so let's move on. All right, so you have your pre-judgment period, and I guess the attorney has to decide whether there's going to be a pre-judgment remedy. All right, then we go to either a judgment or a default judgment. There's no real difference in state court between unless someone can speak up and tell me different. In bankruptcy court, obviously, for 523 purposes, a default judgment is a very different animal than a judgment. And I think most bankruptcy judges are going to look at it askew whether or not he or she's going to honor that. Anyway, so then you have your issuance of writ of execution or garnishment, which you deliver to the sheriff, and then the service of the garnishment. The garnishee has to answer and either surrender the property or wages, depending on what's being garnished. And if there's a failure to surrender, then you've got ancillary litigation going on. With regard to the levy of execution, you've either got property seized or no property seized, and that was the nulla bola return that we discussed last week, which is prima facie evidence of insolvency. So that's kind of an overview of what we're going to be talking about today. Okay, I'm on page 34, and I'm at the bottom of page 34, and you realize that California is a comparatively new state. but I guess some of the states are much older and they still allow body execution. Tin house firms had some experience with that, with body execution. You want to, Tinho, you want to give us a rundown on that?
Okay, so we did have an article published in the NABT journal, I think in the past couple of issues, about civil contempt and body detention. So basically the Supreme Court said civil contempt has coercive power. Bankruptcy judges only have civil contempt power. And the quintessential civil contempt power is for the court to place you in custody until you decide to purge your contempt. This is the last resort, but unfortunately, our firm has a number of people who won't be deterred by monetary or injunctive sanctions. And it was last week we actually had 3 separate hearings on body detention, very unusual, but
Wow, you're busy.
we have one debtor who's been incarcerated for over a year. She refused to turn over the homestead proceeds after the exemption lapsed. She instead spent them all on appeals and the appellate fees, and she took out a bunch of cash. So she's been in jail for a year, and she refuses to tell us where the cash is. She instead wants to keep litigating.
Wow.
Richard also has somebody who's a vexatious litigant. Their case was filed in 2011, and they're under civil and criminal contempt. And only recently were they brought into custody, and also the wife, because they just keep filing stuff. And so the judge said, "Will you withdraw this? Otherwise, you're going into jail." And they said, "Okay, fine, we will." So body detention allowed in bankruptcy.
How do you set up mechanically the deadline for turnover of the homestead after 6 months? Do you put it in the sale order?
I think it's judge specific. For example, Judge Johnson in Riverside has this procedure by which he says the homestead money is deposited into a blocked account and it can only be released with the consent of the trustee and an order of the court, because he realizes that if a debtor's not going to reinvest the homestead, the debtor's going to spend it or funnel it away in some way where it's impossible to recover. Usually we don't like to put that kind of stuff in the order because we hope that they'll just reinvest it instead of having us need to come after it.
There is some case law that suggests that if the debtor doesn't have dominion and control of the money, the 6 months doesn't start to run.
Right, because it's an actual receipt is the statutory language.
Right.
So you kind of have to let them touch it. And then when they touch it, they do whatever they want with it. And then I think that's why trustees love to hate the rule, because it's a source of recovery. But when there is a recovery because it's not reinvested, it's not like it's just sitting there in a big pile. You have to go chase it.
Leslie?
Yeah, I really haven't, I grapple with this one a little bit because there isn't a good way to you can't, like you said, the case that doesn't allow you to recover if they didn't have access to the funds. So there's not a way that you can hang on to those funds. They have to be in the debtor's possession in order for them to spend them. And then if they, forget or just aren't well advised, then you just wait for that 6-month period. But are you just going to keep a case open that is otherwise subject to being, closing for that possibility? And then what do you just check in after 6 months and see what they did? I mean, I don't know. It seems a little bit
Overreaching.
Yeah, or not underhanded. It's not that strong. That's too strong of a word, but tricky maybe. I mean, I don't generally do it, but I mean, if it was if a case that I was staying open for another reason and we hadn't abandoned the property, which I think is probably a necessity as well, then normally we abandon property right away if we're not administering it. So it doesn't apply too much to me.
In my case, if the debtor has engaged in inequitable conduct, I will do it. But if they willingly surrendered their house, I consider that done deal. You know what I mean? The money's yours. And I'm just gonna close the case.
I think that's right.
So, any other thoughts on this issue?
We do settle the reinvestment right for consideration. We say, we're not going to look at this. Just give us a little homestead carve out.
Oh, do you?
Yeah,
Wow, look at that.
you get a little bit.
I have never heard of that, man.
There you
Wow.
go.
Huh. So how much do you ask for? 10% or what?
It depends on how much we appreciate the debtor's cooperation, like you said. Usually it's, they consent to sell the house, and then we're like, well, we don't know what the sale price is. You got a thin slice, but how about this? You carve off a piece of your homestead. We won't go after the reinvestment. You do whatever you want. And then no one has to worry.
Okay, well, let's talk about that for a minute. I do that, but not in that context, and it doesn't come down that way. If a house is in foreclosure, I do ask the debtor, do you want me to sell the house? And if so, will you split your homestead with me? And I'd say, Lucy, how often does that happen? Quarter of the time? 20%? I'd say 20%, something like that. So I've got a case right now where they're doing it. But I've never tried after the fact, before I give them the money, to say, will you give me a carve out? But this is a good example of know thy judge. So you would have to know your judge very well before you did that. Mike, any comments?
Not at this time. I don't
Okay.
want to
Go ahead.
ever have to come up on those issues representing a debtor, that's for sure.
Oh, you've never had a homestead issue?
Closest I came is I had to reinvest. My client needed to reinvest within the required time period, and he finally did. Otherwise, they were going to go after the proceeds.
All right, let's move on. So I am on page 35, and we're talking about executable property. And now we're getting into state law exemptions. And they point out that there's three main categories of state law exemptions. First is exemptions in favor of individual debtors. Broadly speaking, exemptions are intended to protect some of the debtor's property so that seizure by creditors does not leave the debtors destitute. And certainly in California, recently, we've had gigantic increases in exemption amounts. And I guess the public policy is that people should not leave, or citizens should not be left destitute, such that the state has to pay their bills when creditors are benefiting. So the idea is that creditors should pay their fair share, as should society, when an individual is insolvent. So for example, we have a $680,000 homestead here, approximately, which goes up every year. But it seems that it's being constantly chipped away with this case and that case. So we'll see. Okay, moving down, exemptions of statutory benefits. A statute conferring a benefit such as a pension or disability benefits you cannot levy on, and the statute typically says that. Moving on to page 37, some assets are not executable because of various different public policies that are recognized by statute or common law. For example, a state will prohibit the assignment or transfer of liquor licenses, whether by voluntary or involuntary means, if it wishes to maintain control over the qualifications and character of those who are permitted to sell liquor. Does anybody other than myself have experience selling liquor licenses through bankruptcy? Leslie?
Yeah, I've sold a few. I had one of the grandfather of all liquor licenses that was able to stay open almost 24 hours a day and to do off sales, which selling liquor over the counter to go basically, which those don't exist anymore. They're not, you can't get a license like that. So the value of the license was worth more than the restaurant in which it was operating. I was able to get a pretty good sale out of that. So
What city was this?
in northern northern San Diego County.
Wow.
Yeah, it was an Encinitas area. Encinitas, yeah, I guess still considered Encinitas. Good little place. Bad debtor, but good place.
The first thing, well, let's talk about liquor licenses. Do you use liquor license escrows down there?
Yes, I would highly recommend that.
Right.
Because there's always, you gotta figure out the taxes.
And that brings up a good point, is that if payroll taxes aren't paid, Leslie, then they're a lien against the liquor license.
Yes, and other types of taxes potentially as well. So you gotta know what you're dealing with.
In general, a beer and wine license has no value. At least yeah, in general. But a liquor license can. Let's see. Any other thoughts on liquor licenses? All right. Uncertain, I'm still on page 37. Uncertain interests such as equitable interests in property or contingent or unliquidated claims of the debtor are often not executable. It's only legal claims. Publicly owned property is a third example of non-executable property. So if you have a judgment against the city, you can't levy on public property. Okay, moving down to the levy at the bottom of page 37. Levy on tangible personal property is usually the sheriff's act of physically seizing the property, removing it from the debtor, and taking it into custody. Often, the sheriff will delegate this to an individual. So it won't be the sheriff, but it will be a private individual acting on behalf of the sheriff, and the private individual has to post a bond and levies on the goods, such as a keeper. Anybody have experience with a keeper? Can anybody tell me what a keeper is? A keeper, if you have a judgment against a store, let's say a retail establishment, the keeper comes in and sits next to the cashier and takes the money. And then writes out a receipt to the customer so the store doesn't get it. Keepers don't last long because that's a quick way to force a settlement. So keepers are typically there for one day and then that's it. Let's see.
Isn't that otherwise known as a till tap?
Okay. Do you have experience with that?
No, but I've heard of it. I don't want to have experience with it.
No, till tap. The sheriff levies on real property not by physical seizure, but by filing the writ in the real estate records. So they would record the writ in the real estate records. Intangible rights identified in an indispensable document, a negotiable instrument, or share certificate are levied on as if they were tangible goods. The sheriff takes custody. Other intangible rights are levied on by serving notice on the obligor through the process of garnishment. Now, there are some types of assets that have dual systems of registration, such as boats. Boats can be registered state or they can be registered federally. There's also some intellectual property that might be registered in a couple places. So you might have to record in a couple places. Any thoughts on that? Any experience on that? Kristen, have you done that? Have you ever any experience with boats?
I do not have any experience with boats. We have done some sales of intellectual property. And we have a paralegal who is very familiar with the US Patent and Trademark Office. And we've done information about trying to deal with copyrights and things of that nature, but I don't have any specifics.
I agree with you. I would hire someone who knows what they're doing. Let's see. Let's see. Sometimes a writ will specify that the sheriff must levy on specific identifiable property. It's quite usual, however, for the writ to simply indicate the amount of the claim and call upon the sheriff to find and levy on sufficient property. Typically, though, you give the sheriff a heads up as to where he or she should look. Let's see. Moving on to page 38. In summary, levy consists of the actual realization of the court's order or judgment by finding property, placing it in custodial legis, and removing it from the debtor's legal control. Certainly, with regards to bankruptcy litigation, we take a look at the ability of a possible defendant to pay a judgment. And almost always, I don't go after money judgments. I either go after real property or I forget it. I can't remember the last time I sued someone for money and then hope that we'll be able to get it. I don't think bankruptcy court is designed for that. Any thoughts on that?
Well,
Christy?
there are a number of people on the, if you're on the, I don't know if everybody here is a member of the NABT, but yeah, if you're not, you should be. There are a number of buyers that do buy judgments. It's not a huge percentage of what they pay of your judgment, but it's not zero. So that is one avenue if you do get a monetary judgment.
Incidentally, I am not talking about mass preference actions. Obviously, I do mass preference actions, which are for money. I'm just talking of a one-off, lawsuit. And if there's nothing tangible that I'm going to be able to gam onto, like put a Liz pendants on or whatever the case may be to get paid, I hesitate. I hesitate to go down that road. Okay, I'm on page 38. Let's see, it says here, the prejudgment garnishment of the wages of an individual debtor is heavily restricted or altogether prohibited. I've never heard of such a thing in California. Prejudgment garnishing wages, but anybody ever heard of such a thing? No, I don't think that happens. I'm on page 39. Obviously, whatever prejudgment remedy you have is terminated if you lose the lawsuit. Prejudgment remedies are provisional and temporary in nature. So hopefully you'll be able to get a resolution quickly. Prejudgment remedies are awarded before the plaintiff has finally established its underlying case on the merits. I can tell you that in Los Angeles, the best Superior Court judges are in the writs and receivers department, the smartest and the best, because they have to be able to make quick decisions and act equitably, and they have to see which way this lawsuit's going to go, because what a judge doesn't want to do is grant a prejudgment remedy and then have the plaintiff lose. So that's where the rubber meets the road in LA. The defendant is entitled to due process in prejudgment hearings. Obviously, it is an extreme thing to do this ex parte. And if it is done ex parte, then there is, for due process, the judgment debtor is going to be given a chance to challenge this. I can imagine that Tinho, you guys have had experience with ex parte levies, correct? Or you filed them under seal in the bankruptcy court?
I know our firm did that in the past year. I also did get an ex parte TRO in November because the debtor had $500,000 in his wife's bank account that he didn't disclose, and he lied about it at the 341A. And now we're doing a turnover stip after the judge said last chance, next time contempt.
So, at your office, do you have like pirate flags on the wall or anything like that? Or
I used to have a basket where I had all my sanctions orders in, but it got cleaned out.
enough said. Okay. Let's see. Moving on to page 40 and attachment. Attachment is only available in certain situations. The remedy of attachment allows the plaintiff who has an unsecured claim to have the sheriff seize the defendant's property early in the case and keep it in legal custody so the plaintiff finally obtains judgment. The property is available to be executed upon. Like all prejudgment remedies, attachment is ancillary to a suit on a substantive claim. It only becomes available once the plaintiff has commenced suit on the claim. Typically, moving down the page, it's not allowed for consumer debts or unliquidated debts. And in some states, plaintiff must show special circumstances such as evasive behavior by the debtor. Traditionally, attachment is available only in legal actions and not equitable suits. However, equity as a procedure, sequestration, that follows a similar purpose. So the idea here is that if you get an attachment on real land and you record it, then your priority, which we're going to discuss in a minute, relates back to the recording date of the attachment, not to the judgment. Okay, let's see, moving on. Prejudgment garnishment. Prejudgment garnishment is personal property in the possession of a third party or an intangible obligation owed to the debtor. In other words, prejudgment garnishment is the proper remedy when levy involves a third party, either a possessor of the debtor's personal property or an obligor on an intangible right of the debtor. So what this refers to with regards to prejudgment garnishment is when you find the debtors of your debtor, and then you hit them with a garnishment so that whatever money they owe to the debtor, they will pay to you. Or pay over to the sheriff and then pay to you. I can't remember the last time I saw that in bankruptcy court. In other words, that this had happened in state court. Can anybody give me an example they've seen this? Typically, when the debtor lists accounts receivable, I would say almost always they're worthless on Schedule B, because if they haven't gotten them, they're probably not collectible. Additionally, when the trustee asks the debtor for the books and records, typically they say they don't have them. So anybody have experience otherwise?
I've collected substantial accounts receivable, but it's
In what Leslie, in what context?
well, most often for a company's accounts receivable, but individuals as well sometimes. I mean, they're yeah, I mean, sometimes all it takes is a letter from a fiduciary saying you got to pay me, and the letterhead is enough to wake somebody up and have them pay. That's worth a shot.
Have you sued?
Yes, only if there's some analysis done on that it's worth suing, because there's there's merit to the claim, and there's maybe some money behind the payee or payor, I guess.
Did you sue in state court?
No, I don't think we've ever done that. Have we
Krista?
done that, Chris?
No.
don't think we've done
No,
that.
thank you.
Yeah, I think there is a jurisdictional issue.
Yeah,
There.
can
Yeah.
be. Yeah.
Yeah, so something to remember. I'm sorry, go ahead.
In the concept of receivables, how are you trustees treating ERC tax credits?
We're letting them know where to send the payment.
Let's see, I would defer to Leslie, however. I have seen much discussion of this, but I've never seen anybody collect any money. Leslie?
Yeah, I think we've got some that are pending, or either for.
Oh, yeah, so do I, but the money never comes.
Well, I mean, everything's kind of on hold now, so it's not coming for a little bit, but But I think it's, you know, I mean, I think just notifying the IRS of where the money needs to go is worthwhile if they do ever get around to administering them again. Then hopefully you get it rather than the debtors get it.
I've approached a couple of accountants and they weren't interested. So maybe if the climate changes, well, I guess we'll see.
Yeah.
Okay, so let's see, moving on to page 45, prejudgment replevin. Prejudgment replevin is also called claimant delivery, is a provisional remedy derived from the common law action of replevin. Replevin is a possessory action at law for the recovery of specific tangible personal property that has been wrongfully taken and detained or lawfully taken, but therefore wrongfully held by the defendant. Such as they stole your trailer, they rented a trailer from you and stole it, or have kept it or have converted it. In its prejudgment version, it is only available to a plaintiff who has the right to immediate possession of specific property. It can only be sought when the principal action includes a claim of possession of the property in question. So typically this occurs when self-help has failed. In other words, the repo man has not been able to get the car back. So then I guess you go to replevin. However, I found repo men to be tenacious, to say the least. And if you park your car 6 blocks from your house, they're going to find it. So I don't know. I don't know. Let's see. As to concerning the property, the creditor is obliged to protect and preserve the chattel that's been the subject of the replevin, and you have to put up a surety bond. Okay, moving down to receivership. Although receivership has been codified in many ways, it's an equitable remedy, both pre-judgment and post-judgment. A receiver takes control of the business or an asset. Like attachment, receivership removes property from the debtor, but it differs from attachment in that it allows the property to be actively administered or conserved to prevent its deterioration. The powers and duties of the receiver are defined in the court order. The receiver is an officer of the court. You should realize that obviously with regards to 543 of the bankruptcy code, you've only got so much time to get a receiver out. I think it's 120 days, after which there's a presumption that the receiver should stay in possession. A receivership also has implications in involuntary bankruptcy because it can be prima facie evidence that the debtor is insolvent. Any thoughts on receiverships? Injunctions. Courts of equity have the discretion to issue injunctions to restrain or compel action that is likely to cause irreparable harm to the applicant. The injunction is widely used as a remedy that is not codified. I think Tinho was just talking about TROs, right? That you used TROs ex parte to try to freeze funds. The debtor can be punished for contempt of court if the court issues the injunction and the debtor disobeys it. Therefore, unlike the remedies above, the injunction does not result in removal of the property from the debtor, but relies on sanction of contempt of court to persuade the debtor to obey the court's order. So the injunction is a very different fish. It focuses not on the asset, but on the judgment debtor herself. Thoughts? Okay, moving down to lis pendens. When a suit is in progress in which title, possession, or other real rights and real property at issue, the creditor may file a notice of pendency, or in the case of Leslie, a notice of bankruptcy case affecting real property. The doctrine of lis pendens is not a prejudgment remedy, properly speaking, but it does provide some protection to a creditor. Any questions so far? Okay, so as I said at the start of this class, as an attorney for a debtor, you've really got to get into the weeds and look at these different lawsuits and see what's there before you start assembling the schedules and statement of affairs, and that gives you a chance to better advise a client. For example, a bit of attachment is something that you need to know about. Okay, moving on to the judgment and its enforcement. Judgment by default or consent. Default judgment. If the debt is a liquidated contract claim and personal service has been affected, some states follow traditional practices of allowing the clerk of the court to grant the judgment. They make a point here that a debtor normally can't appeal a default judgment, but may have grounds to apply for reversal of the judgment for excusable neglect. In other words, the default judgment debtor typically can't appeal the judgment, but he or she can collaterally attack the judgment. With regards to consent or confession to judgment, as a trustee, this is a good example of why I said what I said 10 minutes ago. Sometimes I'll be in a situation where an individual owes me money as the bankruptcy trustee, and they're willing to sign some kind of confession to judgment. I dislike this so much. First of all, it keeps the case open. And second of all, what do you think is going to change in 6 months or a year? The person doesn't have money now, they're not going to have money in 6 months or a year. Anyway, the book says that this kind of thing is disfavored. Courts are less likely to accept a confession of judgment that is executed by the debtor at the time the debt is incurred. In other words, this is part of the package. In other words, you confess to the debt when you take possession of the goods. This type of advanced confession of judgment is called a cognivant or a warrant of attorney. It appoints the creditor as the debtor's agent so that the creditor confess to judgment on the debtor's behalf if the debtor should default. This type of advanced waiver to defend a debt collection suit abandons the debtor's due process rights and has a high potential for abuse. So it's highly regulated by the courts and legislature. Okay, so I think I mentioned it that last week, but let's make sure we go through this again. There is at least one debtor's law firm that appears before me that is actually investigating the debtor's creditors, and where there's been abuse of some kind of federal statute, they carve that out and they claim it as exempt. So they put it on Schedule B and then they exempt it on Schedule C. And then they have another firm go after them, and they've got the creditor, and they're making money on this. They're making money on this. And it seems like they do it if the liability of the creditor is $15,000 or more. But anybody have any knowledge of this? Anybody seen debt? Christy, have you seen debtors counsel do this?
I know what you're talking about, and I've done it myself, actually, as in just send a demand letter to the creditor, or tell them, kind of threaten them.
Really?
Gently,
What
and
happened?
get money. I have gotten money for the violations, but it's not a general, I guess I don't do it like the other firm, where it's a part of their practice and a side practice, yeah.
Oh, okay.
But I do ask about it because I remember you saying it years ago when we used to go in person to the hearings, and I remember you mentioning it, and I thought, yeah, that's important. So, and I do ask them because yeah, if they're getting abused, then I want to do something about it. Yeah.
The interesting thing is they've actually made it into a business. Debtors counsel actually made it into a business. Okay, moving on down. Duration of the judgment, page 48. In California, judgments last 10 years and they are renewable for another 10 years. Going on to page 49, judgment liens. Upon being docketed, top of the page, the judgment creates a lien on all real property in the county of which the debtor is the legal owner of record. Now, with regards to personal property other than cars, you do a judgment lien, personal property, JLPP, and you record that with the Secretary of State. The lien is subject to any pre-existing third-party interests recorded in property, such as prior recorded mortgages and liens. The judgment lien may also be junior to an earlier unrecorded interest in the property by the debtor to a good faith transferee for value. So the point is that when you have a judgment lien, it only attaches to whatever rights the debtor has. So if the debtor doesn't have all the rights in the property, then you don't get all the rights in the property. A judgment lien does not take precedence over any exemption. Once the judgment is recorded, it attaches not only to the real property held by the debtor at the time of the filing, but also to any real property in the county acquired by the debtor in the future, as long as the lien remains in effect. So on occasion, we have recorded a judgment, and then when we go for our to close the case and our final decree, we carve out the judgment so that it stays with the estate and it's not abandoned to the debtor. And then if it ever hits in the future, as sometimes it does, then we reopen the case. Anybody and administer the proceeds from the sale of the property and reconveyance the judgment lien. Any thoughts on that? All right. Obviously, judgment liens, trustees have to look for phony judgment liens. You don't see them very often, but if the judgment is phony and can be attacked as a fraudulent transfer, then once again, you're ahead of the debtor's homestead. So I do look at the judge. First of all, I get a preliminary title report. I pull a preliminary title report on the real property I'm interested in, and I see what judgment liens there are. And then I go and look at the state court docket and look to see if there's anything funky. And if everything's clean, next case. If not, I retain counsel to start digging deeper. I once had a case where I volunteered for my alma mater, and I was doing student interviews. And I was given a list of everybody that had applied to the college. And I saw a judgment debtor. One of my judgment debtors was on this list. I didn't interview this person. And I thought, this was a case that was open for a couple of years. So I guessed this judgment debtor, who was a daughter of a kingpin, so to speak, a slumlord. I guessed that the slumlord would buy her a house where she was going to be going to school. So, true story. So I waited, because the case was open for several years, and then lo and behold, she did buy a house, and it was in her name, and I levied on it. I domesticated the judgment in the other state, levied on it, and got paid. So you never know. A prejudgment lien does not take precedence over any exemption. Counties. So how do people decide? Anybody got any thoughts on this? How do you decide what counties to report in? The county they live in, of course, but any other counties? Tinho?
We just do like a Lexis search, and if anything pops up, we record there. Otherwise, we try not to send the recorder's office too much money.
No, that's true. That's true. But maybe you would talk to creditors who might know something, you know. Let's see.
Hey, Wes.
Go ahead.
Quick question. Getting back to your previous comment, did I hear you correctly that sometimes where you as trustee have a judgment lien against a debtor, you can request the case closing subject to the right to reopen if you want to take action on the lien?
We do that routinely. Leslie?
I've done that before as well. Just not keep an asset that is not administered, and the court can reserve jurisdiction to reopen the case in the event that there's proceeds to come of it. And we've reopened cases on that basis as well.
Mike, does that come as a surprise to you?
Yeah, I'd never seen that. So because the clerk's typical closing is, doesn't mention that. So I would imagine that you'd need to make a special motion for the case closing language.
Let's see, Lucy, have you rejoined the call? Let's see, is she there? Lucy handles that, but there's no motion. It would just be put in the final report.
Sorry. I'm here, but my toddler's screaming in the back. That's why I have it
All
off.
right,
What was
did you hear the question? How do you reserve an asset? In other words, we're not abandoning assets such as a judgment, and then they close the case. How do you do that procedurally?
we have a motion that we file. No, is it
Okay.
a
I thought you just put it in the final report.
I definitely make a notation in the final report and I say this asset hasn't been administered and trustee may reopen it. I put that in the order for the final report as well.
I think
We
usually
file a
notice of
motion.
intent for it, but so it doesn't require a hearing, but there is a notice, an opportunity to object.
Okay, so you notice it?
I think I'm pretty sure we do. Yeah, I think we do a notice of intent.
Okay. We've never had this, Lucy, we've never had this challenge.
I haven't had it challenged, but I know that there was like at least 2 cases where they were open and we were waiting on it. And I think we're still waiting. Nothing has ever happened. We're like a civil lawsuit to unfold and see if anything's going to come from it. So we just did the final report and made a notation. I do think we filed a motion, Wes, or filed something in the case as well. I can probably find it.
Yeah, I think we do the notice of intended action so that we have a bankruptcy court order preserving that asset for the estate.
That sounds wise.
Wouldn't you,
Go ahead.
Sorry.
Go ahead, Mike.
What? I'm just trying to wrap my head around this. Wouldn't you need a non-dischargeability judgment against the debtor?
No, it's not the debtor. It's not the debtor. It's a third party that owes money to the estate.
A third party. Okay.
It could be the debtor. I mean, it's just a reservation of it's keeping the estate open basically, but without the court being open. So the court can administratively close, but the asset is still part of the estate. And if there's ever any collection on it, then the case reopens and we administer it. So don't lose my standing as trustee.
We have a silly case where the sole asset of the estate was the debtor's interest in a deed of trust against real property that only triggers when his mom dies. So we close the case and every couple months we check if the mom died. We're going to reopen it when the mom dies.
And how are you going to know when the mom dies?
One, we could ask, but that seems kind of rude. 2, since it's recorded on real property and we have a court order on this and a settlement with the major creditor in the case, if anything happens, we'll find it and make a big stink about it.
All right.
I'm just looking at, it just seems like it's a carve out of the debtor's discharge in the case where you have a judgment against the debtor and a lien or whatever.
Yeah, but
It really doesn't have anything to do with the discharge because the debtor's already discharged, whether or not a trustee administers assets or not. So it's not, it's an estate asset. Doesn't have anything to do, the debtor's discharge doesn't have anything to do. The debtor still gets a discharge if I'm administering assets. So I have the choice of just staying open to administer that asset when it happens, like in Chinho's example. That's a prime case for when we would do something like this. There's an event that's going to happen in the future that's going to remove the contingency of that payment or something like that. There's no sense in having to do our annual reports on the case and all the other things that trustees have to do in the meantime before that contingency happens. So it really doesn't affect the debtor, except that we're not abandoning the asset.
You also only get a discharge of pre-petition debts, Michael.
Yeah.
You don't get a discharge of post-petition debts in Chapter 7. All right, let's see. Moving on. Judgment, enforcement of judgments in other states. The Uniform Act provides for a straightforward method of registering a foreign judgment by a clerical act. This is a simpler process than the traditional means of enforcement. Judgments of the courts of foreign nations are not entitled to full faith and credit under the Constitution, and they are not subject to the same procedures of laws that govern the judgments of other states. However, principles of international comity do favor the recognition of such judgments when the judicial process of a foreign nation satisfies standards of fairness and due process. I have seen Vietnamese judgments, but that are related to the Shmata trade or garmentos. But that's all I ever see with regards to foreign judgments. As far as domestic or American judgments that are foreign judgments, I believe you can get a deficiency judgment on foreclosures in Florida. And I believe they are common. And people who live in California who have Florida vacation homes that they let go find those Floridian deficiency judgments finding their way here. Anybody had any experience of that? No. Christy, have you seen that?
Have not.
All right. Moving on.
I had to happen once, Wes, actually. It was a Chapter 13 in the Northern District. Yeah, it culminated in an adversary proceeding, which thankfully got swiftly settled because right at the eve of the judgment being fully domesticated, the 13 was filed. So I saw no purpose in the AP as there's full faith and credit for a judgment from an out-of-state court, but state court counsel from Florida felt the need to refer it out to bankruptcy counsel in the West Coast, and it ended up causing more trouble than there needed to be.
I suspect that people buy up these deficiency judgments for pennies on the dollar and then pursue them.
Possibly, yeah.
Just a word to the wise, if you're defending those, you want to look at the timing of it. We had one recently where we were able to knock it out because it was basically past the renewable time period, and each state is different as to what those are.
We've just had a call join us. The telephone number is 323-819-2868. I think you're on speaker. If you could take it off speaker, thank you. All right, so let's see. I'm on page 51. The execution. The creditor must resort to execution to enforce the judgment, whereby the sheriff or equivalent official is directed by a writ to find property of the debtor. Upon strict compliance with statutory requirements and invalidated, they have to strictly comply with statutory requirements, otherwise they have an invalidated execution. The writ of execution begins the process by having a writ issued by the clerk of the court directing the sheriff to find and levy on property of the debtor and to report back to the clerk by a specific date called the return date. After issuance of the writ of execution, the sheriff tries to levy on property of the debtor, often with the creditor's active advice. After levy, the sheriff files a return reporting the action taken and describing the property that's been levied upon. Moving on to page 52. After the levy, then you have the execution sale. As soon as possible after completion of the levy, the process of realization takes place. After advertising notice to the debtor conducts a sale of the property by public auction. The sale procedures provided prescribed by auction statutes attempt to ensure that the fairest price possible will be obtained. Notwithstanding this, it is generally accepted that the value of the property is depressed at forced sales of this nature and are below true market value. I think last week we talked about the direct case, a famous case from back east that has a 70% rule as a marker of whether, in other words, the foreclosure can be attacked if 70% of fair market value wasn't obtained. The statute may afford special protection to the debtor where real property is sold at execution. These protective mechanisms may be only available when the debtor's residence is being sold. The problem is you've got the homestead, but not only that, I don't know how many people here have attempted to execute on real property in state court, but it is quite difficult with regards to bonds and getting title insurance for the buyer. Any thoughts on that? Any experience of that? It's something that is kind of a specialty. For example, the statute may require an appraisal of the property before the sale and will not permit the sale at a price that is less than the defined percentage of the appraised value. I know in California, if you're doing execution of real property, an execution sale, you have to get an appraisal and file it with the court. Some states provide for an automatic confirmation hearing. Others will look at it and will stop it if there's some irregularity in the proceedings. Okay, moving over to redemption. One of the things that's always puzzled me is that California is so liberal to an extreme if you look at what's been passed recently, and yet there's no redemption law in California. I think that's astounding. Any thoughts on that? Because of this, when a debtor has suffered a foreclosure and comes to debtor's counsel and says, what can I do? There's not much that can be done. I mean, lots of luck going to state court and collaterally attacking the foreclosure. I don't think I've ever had a case. I don't know, Leslie, have you ever had a case involving a foreclosed property out of state where there might be a redemption, right?
I haven't really concerned myself with it much since I don't think it would benefit the estate. No.
Let's see, execution liens. An execution lien attaches by operation of law to any property foreclosed upon. Like the other liens discussed in this chapter, it falls in the general category of judicial liens. The purpose of the lien is to protect the creditor while the sale is pending. The sale is supposed to proceed expeditiously after the levy, so the lien is intended to be a fairly short duration and to last only as necessary to cover the property realization by the sale. So while you're waiting for the execution sale, you do an execution lien. Okay, moving over to garnishment on page 54. We've talked about garnishment a bit. Moving on to page 55, proceedings in aid of execution. The creditor's bill in equity. This is something else that is useful in California. If you do a judgment debtor exam and you serve with a judgment debtor exam, that has implications as to insolvency. However, I don't know if you're aware, but the laws changed dramatically in terms of when you can do a judgment debtor exam. And the California legislature has given judgment debtors tools to avoid it. Any comments on that? I was doing a judgment debtor exam when 9/11 hit. In Pasadena court. That's what Wes was doing when 9/11 took place. Okay, moving over to page 56, we've got a discussion of fraudulent transfers, actual fraud and constructive fraud. Obviously, we're going to discuss this more in the future chapters. We're going to get into it. However, they point out that there's a 4-year statute. In California, we have a 4+3 statute. 4-year statute plus an additional 3 years for notice, up to 3 years. Let's see. Moving over to page 58, Introduction to State Law Insolvency Proceedings. Now, what we're going to be talking about here are compositions, extensions, and assignments for the benefits of creditors. When I was a young lawyer, which seems just yesterday, assignments for the benefit of creditors were common. Now they seem extremely rare. Anybody have any thoughts on that? Why that's so? It seems like all the senior lawyers that used to do them are gone. They've left the scene and go ahead.
I do them.
Okay. Well,
Anybody
then
needs one.
okay, then you're the person to say what happened? Where they all go?
I think you're exactly right. At least the people down here. I mean, I wanted to hear what you had as the reason. I was going to take notes, but I think the primary two people that were doing it were Dick Kibberman and Carl Garner down in San Diego, and they're both passed.
And no one took their place.
I did.
You took their place. So what is the trick? I guess the trick is getting the assignments, right? That's the trick. Not doing them. The trick is getting them.
Yeah, I think it's just getting the word out. I mean, I think I just got one today, so they are happening.
Oh, well, congratulations. All right. Well, then we better proceed here. Okay. Well, all right. So what we're talking, I'm on page 58. When a number of creditors are attempting to enforce their claims, those furthest ahead in the collection process have the best chance of finding executable property. Bankruptcy under federal law is the predominant and most powerful collective proceeding. In other words, to try to create equality among creditors so that it doesn't promote a race to the courthouse. State law insolvency proceedings have one attribute in common with bankruptcy. They're designed to enable the debtor to deal with creditors as a group to achieve an overall settlement of their claims. However, bankruptcy is a much more powerful and pervasive remedy. Among other things, the Bankruptcy Code confers extraordinary rights on the trustee, such as Leslie the trustee's powers under 544A, to collect and administer the estate, and it has unique provisions for the protection of creditor interest, the control of creditor activity, and the discharge of debts. None of that exists under state law. State law proceedings do not have the same comparative strength. They fall far short of being equivalent to bankruptcy and are constitutionally barred from providing equivalent relief. As a result, the proceedings under state law are less formal, simpler, and more dependent on cooperation between the debtor and creditors. State law insolvency is often a less desirable remedy than bankruptcy because it does not give the debtor the same protections. However, the debtor may want to avoid the expense and formality of bankruptcy administration, or may want to avoid the stigma of bankruptcy, or may not be eligible for bankruptcy relief. So I've got a question for Leslie. If we do an assignment, do you have to contact Dun & Bradstreet? Is it part of your record, or can you just do this on the sly?
I believe there is. I've got to dig out all my requirements, but I think I'm not sure if it's Dun & Bradstreet, but they definitely have to give notice to all creditors, and I believe there's some publication notice as well.
Let me put my question a different way. What kind of paper trail is there that will haunt you as a judgment debtor? I mean, if you file bankruptcy, that's it forever, at least for 7 years or 10 years, right? And you got that bankruptcy case number. There's no equivalent with an ABC.
Sure, you've got your assignment agreement.
Right, but that isn't something that creditors will be able to find.
Well, the creditors are supposed to all get notice.
Right.
Yeah.
Well, that was the reason for my Dun & Bradstreet question. You know, is there any kind of reporting agency that knows about it?
No, I know.
Okay, so that's one of the advantages of a composition or an ABC. Let's see, these two insolvency proceedings are voluntary. Only the debtor may bring them. Although creditors may exert pressure on the debtor to make an assignment or a composition, they cannot initiate or force them on the debtor. Under the common law, these insolvency proceedings are not judicial remedies. Unless a state is provided otherwise by statute, the debtor does not apply to court to sanction the proceedings. Okay, I'm on page 60, compositions and extensions. A composition is a contract between the debtor and two or more creditors under which the debtor promises partial payment of the creditor's claims, and the creditors agree to accept this partial payment and full settlement of their claims. So this isn't with one creditor, one debtor. You have to have two creditors. An extension is a contract between the debtor and two or more creditors under which the contractors allow the debtor an extension of time within which to pay the debts. Although compositions have been codified by some states, they're generally subject to the rules and principles of contract law. The distribution offered to creditors, which may be committed from future earnings or the liquidation of selected assets or both, must be enough to make it worthwhile for creditors to accept the settlement rather than to press ahead with such collection efforts. A debtor is therefore able to make a legally valid composition with fewer than all of her creditors. However, a composition cannot achieve its desired end if acceptance of the composition is not widespread. So really what a composition is an accord and satisfaction, to look at it, under the common law. Any comments about compositions? Okay, looking at, incidentally, before we go any further with regard to compositions, there's a section of 523, right? Debtors Council that deal with things like this. Exception to discharge. Maybe we'll wait till we come to the 523, but I know there's something in here that deals with compositions. Okay, let's go on to assignments for the benefit of creditors. An assignment for the benefit of creditors is a voluntary transfer of property in trust by the debtor to another person, the assignee, with instructions to liquidate the property and to distribute proceeds to those creditors who have elected to participate. The purpose of the assignment is to place the debtor's executable property in the hands of an impartial custodian so that the individual creditors cannot levy on it, permitting its orderly liquidation and distribution for the benefit of creditors' body as a whole. The debtor transfers the property in trust to the custodian, specifying the terms on which it is to be realized and its proceeds distributed. So Leslie, do you record the assignment?
I think it would depend on what type of property I'm dealing with, but I don't believe I have recorded the assignments in previous ones that I've done, but
No.
I would rely on my paralegals to whether or not I need to do that under the California state law.
Okay. Let's see. The ABC is a common law device, but it has been codified and regulated by statute in some states. An ABC, I'm at the bottom of page 61. An ABC has some similarity to liquidation and bankruptcy. However, the ABC is a weaker and less comprehensive remedy. It does not stay the creditor's pursuits of any unassigned assets or shield the debtor from other collection pressure. So let's make this clear. You can do an ABC, but you don't have to participate in it, and you can continue with collection efforts. However, if all of your non-exempt assets have been transferred to the assignee,
Not much point in doing that. Yeah, no, that's exactly right. I mean, you can continue against the debtor, but if it doesn't have anything left, so normally corporate debtors, then there's no point to that.
Let's see. ABCs usually cannot allow the debtor to retain the use or control of the property. I'm on the bottom of page 62. Or to reserve some interest in it apart from the right to have any surplus returned. So the debtor has to turn over dominion and control of the assets to the assignee, otherwise the assignment's no good. Ownership of the property passes to the assignee, who holds it in trust for the benefit of creditors. The assignee, as usual, acquires no greater rights in the property than the debtor had. On the effective date of the assignment, the property is treated as being, I'm on page 63, and custodial legacy cannot be levied upon. The effective date of the assignment varies from state to state. It might be the date of the instrument's delivery to the assignee, the date of the property's delivery, or the date the assignee accepted the transfer. In some states, the assignment must be recorded to become effective. The assignee's essential task is to notify creditors, call for claims, realize the property, and distribute the proceeds. The proper performance of the assignee's duties is secured by a surety bond. In some states, the assignee is obliged to file an inventory, appraisals of accounts, just like a receiver. Even if the ABC is valid, the creditor may be able to use it as the basis of an involuntary bankruptcy petition, provided that the requirements of 303(b)(2) of the Bankruptcy Code are satisfied. We will talk about this in a future class. Stated broadly, the code gives the creditors the power under some circumstances to override the ABC and force the debtor into bankruptcy. Again, we'll be talking about 543, displacement of receivers in the future as well. If the petition is granted, the assignment is terminated, and the assignee must surrender the property to the trustee, subject to 543. Any questions about Chapter 2? Okay, Lucy, are you there?
Wes, can I ask one question about the duplex, the In Re Ray case you brought up earlier?
Yeah.
I was looking at it again, and it was two separate structures. Like the debtor lived in a house, and then she had he or she had a duplex that was rented out.
But there's one APN.
True. So I filed the case. I tried to file the case last year that had a duplex. My client lived in one side, and then they didn't rent out the other. They used it like storage. And there was no, it was before this case came out. But my question is would that be subject to this new?
I think there's a lot of ways you can go on this. I think this has to be clarified. You know what I mean? Because there's many permutations here.
Yeah, true. Okay.
Let's see. Does everybody have their calendar up? How does March 1st or March 15th look to everyone? That would be at noon Pacific time. Any thoughts?
I like the Ides of March the best.
I like March 1st, if that works well for everybody.
Okay, so we got one vote for March 1st, one vote for Julius Caesar and March 15th.
I'm on the 15th. I have a planned deadline on the 1st. I prefer to.
Okay, is the 15th okay? Is anybody against the 15th? Okay, I'd like to thank everybody for attending today. I hope you have a nice weekend. We have a big storm in California coming Sunday night, so wish us well to stay dry. And so we'll see you on noon, March 15th, and Lucy will be sending out the MCLE certificates for today and Zoom instructions. Thank you very much.
Thank you. Thank
Thank
you very
you.
much. Great weekend.
Thank you.